مرحبا وأهلا بكم في برنامج داخل واشنطن. معكم مضيفكم روبرت ساتلوف. على خلاف النظم الديمقراطية البرلمانية حيث تملك الأغلبية في الفرع التشريعي فرصة السيطرة على الفرع التنفيذي. في النظام الأمريكي الفرعان التنفيذي والتشريعي مستقلان تماما. أحيانا مثل الآن يمكن أن يسيطر على هذين الفرعين حزبان مختلفان يحملان آراء مختلفة اختلافا جذريا حول كل شيء، بداية من الضرائب والانتهاء بالزواج المثاليين. في هذه الحالة من يتخذ القرار؟ كثيرا ما تؤول تلك المسؤولية إلى المحكمة العليا التي يمكن أن تكون لها الكلمة الأخيرة حول حتى أكثر القضايا الأمن القومي حساسية. يشمل هذه الأسئلة مثل متى يكون للرئيس الحق في استخدام القوة في الخارج، ومتى يمكنه التطفل على الخصوصية مواطن هنا على الأرض الوطن. هذا الأسبوع من برنامج داخل واشنطن سنناقش دور النظام القضائي وخاصة المحكمة العليا هي القضايا الأمن القومي مع واحد من أكثر المؤلفين القضائيين تبصرا في أمريكا، وهو بنجامين ويدس من معهد بروكينغز. Welcome back to Dakhil, Washington. We're here today to talk about the intersection of law and national security. And with me is Benjamín Wittes. Ben, thanks for joining us today.
Thanks for having me.
So let me start with a very basic question. Is America currently at war?
Well, it's a very basic question, but it's not a simple question. So the short answer to it is, legally speaking, the United States considers itself currently at war with Al-Qaeda, with the Taliban, and with associated forces of those two groups. Now, associated forces is potentially a fairly sweeping idea that includes groups like AQAP,
Al-Qaeda of the Arabian Peninsula.
Yep, and as well as groups like Gulbutin Hekmatyar's group in Afghanistan. So it's a fairly sweeping concept. So legally speaking, the answer is yes.
And are there any geographic limitations in law on where the United States considers itself at war?
So the answer to that is actually complicated, and the answer is sort of yes and sort of no. So there are, in the authorizing document for the current conflict, which is the authorization to use military force from 2001, there is no geographic term specified. So, the idea is the conflict sort of follows the enemy. On the other hand, there are countries to which the conflict does not follow the enemy. You will not see U.S. military forces in London, in Paris, or in Cairo. And so the basic idea is that where there are law enforcement options, where there are means of getting to the enemy that don't involve the use of U.S. military force and you don't have the sovereign consent of the countries in question to operate, and you have other means to do it, we don't think of the conflict as reaching those places. On the other hand, where you either have the consent of the country in which to operate, like for example in Afghanistan, or where you don't have effective law enforcement options, the conflict does reach, in a military sense, those situations.
Now, the President and many others have talked about a new authorization for the use of force. What's wrong with the old one? Why do we need a new one? And what would be different about this?
Well, so there are really two things wrong with the old one, and they're somewhat at odds with one another. One is that it's too broad, and the other is that it's not broad enough. So it's too broad in the sense that it has no geographic limitations, right? It has no temporal limitations. It doesn't, it could theoretically go on forever. And it is tied to these associated forces, which, can almost mean anything you want it to mean, or at least so a lot of people worry. So people worry that it authorizes endless war anywhere against whoever. On the other hand, if you look at the text of it, it is very tied to the September 11th attacks. It authorizes force against those people and entities and organizations and countries that were responsible for 9/11 and those that harbored them. And a lot of the groups that we're fighting now, including most notably ISIL, really didn't exist at the time of the 9/11 attacks. And so it seems like an oddly constrained instrument in order to address some of the policy problems that the United States is using force now to address. So the argument for it is both that you could impose a certain amount more discipline on the conflict if you had a new AUMF, but also that you could describe more accurately the conflicts that you are fighting today rather than the conflicts that you thought 13 years ago that you were likely to be fighting.
So you think it would be a good idea?
Oh, it's long overdue.
Long overdue. So we've been talking about some of the vagaries of the state of war. Let's talk a bit about how we prosecute this war. This war has seen the innovations, for example, in the use of drones. And one of the most interesting cases was the killing of an American citizen, Anwar al-Awlaki, in Yemen. What is the legal issue surrounding the targeting of this really bad guy in Yemen?
Well, so there are a number of possible legal issues. One is, under what circumstances does the United States, under domestic constitutional law, have the lawful authority to target with lethal force one of its own citizens? And that's a somewhat unprecedented thing. We normally, now it's not to say that it's never happened before that we've killed Americans in combat. During World War II, certainly there were Americans in both the German and Japanese armies, but we didn't generally do operations specifically to get them, right? You hit a German position, and if one of the guys who gets killed is an American, no one probably even noticed that. But the decision specifically to target a person whom you knew to be a US citizen raises an interesting set of constitutional issues that the government had to resolve before it was done. So the second issue is, are there international law issues associated with drone strikes in countries that are not the field of active combat, as Yemen certainly was not at that time. And that's not a domestic United States issue, that's an international law issue. There are law of war issues. When is it okay to target somebody you believe to be a senior operational commander of a opposing force? And then there are sovereignty issues, which is, in this case, was, I think, probably alleviated by the fact that Yemen kind of allows the United States to do these drone strikes. Pakistan, for example, has a much more complicated relationship with it, sometimes allowing it, sometimes denying that they allow it. And so the question of what sort of consent do you need from the territory from the country on whose territory you're operating is a very complicated one. And under what circumstances can you do it without that country's consent is also a complicated question.
And so in the end, after posing all these questions, the Obama administration came up with the conclusion that it was validated.
The Obama administration's conclusion is, one, Al-Qaeda in the Arabian Peninsula is an associated force of Al-Qaeda. Number two, it is therefore covered by the AUMF, the authorization to use military force. Anwar al-Awlaki is a senior operational leader of Al-Qaeda in the Arabian Peninsula, poses an imminent threat, continuing an imminent threat because he's constantly planning terrorist activities against the United States. Yemen gave its consent to the operation. and therefore there's no sovereignty issue involved in that. And as long as you hit the target with obeying the concepts of distinction and proportionality, trying to avoid civilian casualties to the best that you can, there is no lawful impediment to the strike. And under those circumstances, there's no impediment under either the Fifth Amendment right to due process or the Fourth Amendment right against unreasonable search and seizure.
We just recently learned in the United States of an earlier targeting of a foreign terrorist leader. This one not part of Al-Qaeda, actually quite the contrary, a Shiite leader, working in concert with the Israelis to kill Imad Mughniya. Would any of these issues that you referred to earlier have been raised and dealt with in a legal fashion in that circumstance?
So it was certainly, of course, there would have been extensive legal review. One thing you should understand about the U.S. counterterrorism efforts is that they are lawyered to a degree that is hard for people who have not been involved in them to understand.
When we come back, we're going to talk more with Ben Wittes about the role that courts play in these national security questions in just a moment. Benjamin Wittes is one of the most insightful and widely quoted experts at the intersection of law and national security in America today. He is a senior fellow in governance studies at the Brookings Institution here in Washington and the co-founder and editor-in-chief of the Lawfare blog, a must-read, web-based home for sober and serious discussion of these issues. Ben graduated from Oberlin College in 1990, and don't mess with him, he has a black belt in Taekwondo. So, Ben, earlier you said that the administration had to address these legal issues and that there's an army of lawyers. But who would know? Do courts, do third bodies actually do oversight on these internal deliberations that administrations do?
It depends on the issue. So targeting issues like strike on Anwar al-Awlaki have never been reviewed by courts, and that is actually the subject of serious discussion now. The lawyers for al-Awlaki's family are trying to get the legality of that strike reviewed by courts, so far without success. On the other hand, a lot of other issues that come up in the national security context are routinely reviewed by courts. So, for example, surveillance issues, there is a special court that is devoted to reviewing the lawfulness of espionage and surveillance, electronic surveillance requests, including by the FBI and the National Security Agency. And of course, the Guantanamo detentions have been the subject of extensive litigation. Each one of them has been, each one of the detainees has had their cases reviewed at least 2 levels of the federal courts. So some of these courts, some of these national security decisions end up with extensive judicial review, and some of them end up with very little, but only internal executive branch lawyering.
And has the Supreme Court taken a look at any of these basic questions that we've been discussing?
Yes, so the Supreme Court has ruled several times on Guantanamo-related matters. It has also been involved in surveillance issues, although mostly for purposes of saying that it didn't have jurisdiction to be more involved in them. The Supreme Court has a number of cases that are kind of bubbling up through the ranks now that could it could hear in the next few years.
When you look at the Supreme Court on national security issues, does the traditional view of conservative and liberal, hawkish and dovish on, say, social issues tend to apply on national security issues?
On some of them, yes, and on some of them, no. So some of the issues have broken down roughly in that sort of liberal-conservative split with Justice Kennedy as the swing vote. On the other hand, one of the early cases involving a detainee named Yasser Hamdi, who was, like Anwar al-Awlaki, a citizen, unlike al-Awlaki, he wasn't killed, he was captured. And in his case, Justice Scalia sided with the most liberal justice then on the court and wrote a sort of impassioned opinion about how detention was inappropriate in the case of a citizen, and that the only way to deal with a citizen accused of working with the enemy is through a criminal trial for treason. So it has sometimes broken down in roughly left-right fashions and sometimes really broken up traditional left-right divisions.
You mentioned Guantanamo. This is the facility in Cuba where Americans keep foreign nationals principally because they don't want to bring them to the American judicial system. The president has wanted to close it. Despite his efforts, it's not closed. Why is it so tough to close Guantanamo?
Well, it's tough for three reasons. The first is that Congress does not want to bring any detainees to the United States. So if you're going to hold them, and no country will give you permission to hold them in theater, you have them at Guantanamo and you can't bring them here, and you're not going to let them go. They just have to stay at Guantanamo. So that's reason number one. It's just Congress won't let you do it anywhere else. Number two, a bunch of those people at Guantanamo are both difficult to release because it is hard to find countries to take them and resettle them and also keep an eye on them at the same time. But also, some of them are way too dangerous to release. Some of them are very serious Al-Qaeda mid-level and upper-level operatives. And then the third reason is that even some of those who are in that latter category you would never be able to make a criminal case against them, either because of mistreatment that they had suffered, or more commonly, just because the activities that they were engaged in were not crimes at the time that they did them. So there's a basic problem that people are very difficult to release. Some of them are very dangerous. You can't try them, and Congress won't let you bring them here. And so you end up with a very unfortunate, static situation where Guantanamo is something that nobody seems to want, but we don't seem to be able to get rid of either.
Well, if nobody wants it, what about the underlying rationale for Guantanamo? There's still going to be people that we capture in various parts of the world that we're not going to want to bring back to the American judicial system. Is there still a need out there for other Guantanamos, or have we come up with other solutions for that problem?
So here's the good news. The good news is that as long as we are not deploying large numbers of US forces and capturing people in large numbers, there is no particular problem with the criminal justice system for one detainee at a time, two detainees at a time, even 5 or 10. You know, you pick up people in the regular course of counterterrorism business, and the criminal justice system is more than capable of absorbing that. What gave rise to the problem of Guantanamo was when you started getting 10,000 detainees at a time. And you can't, under those circumstances, do the sort of evidence collection that the criminal justice system requires, which is evidence admissible in court sufficient to prove that each individual had committed a crime beyond a reasonable doubt, right? And there's just a volume of people. That's a labor-intensive process for each person. And there's a volume of people beyond which you can't do that. So when we went into Afghanistan and we started getting very large numbers of people turned over to us, both by the Pakistani army and by allied forces in Afghanistan, you often didn't know very much about the people you were getting. In Iraq, I think we had upwards of 70,000 detainees at the height of you can't make criminal cases against 70,000 people. And that's a situation, those are the situations in which law of war detention becomes essential to be able to do. and by the way, equally essential to be able to do in a fashion that's humane and non-abusive. And so as long as we stay out of conflicts in which we are capturing tens of thousands of people at a time, Guantanamo is a legacy problem. We have 122 detainees left there that we have to figure out what to do with, and some of those cases are resolvable, and some of them are going to be very hard to resolve. The day you need a Guantanamo again is the day that you're not capturing detainees anymore by the ones and twos, but by the hundreds and 200s.
Ben, thank you very much. I'm sorry we didn't even get to all my surveillance and privacy and other questions. It's a fascinating discussion. I want to thank you for being with us on Dakhil, Washington.
Thank you.
بهذا نصل إلى نهاية هذه الحلقة من برنامج داخل واشنطن. إذا كانت لديكم أي استفسارات أو تعليقات حول هذه الحلقة، وخاصة حول التوازن بين الحرية الفردية والأمن الشخصي في أمريكا، أرجو أن تراسلوني مباشرة على عنوان البريد الإلكتروني التالي insidewashington@elhura.com. معكم روبرت ساتلوف. شكرا لكم وإلى اللقاء.